Faculty of Law, University of Mulawarman, one of the best in Kalimantan. It is not only held 3 services on higher education. More than that, we have integrated to Kalimantan environment. Kalimantan, 3rd biggest island in the world, having tropical forests across the land. Kingdom of 100 animals, place of 100 plants grow, home of people with unique culture, miles of river winding, wonderful coast, rich in natural resources, a conservation, the earth lungs and paradise, the most breathtaking gift from God for humankind. Today, Kalimantan reveals its darkest side of human greed. Coal mining exploits land without mercy. Mining pits welcoming innocent life. Sand beach is no longer whispering. Even the mangroves disappeared. Waves crashing away. The forest began collapse, destroyed by voracious machine. Kalimantan rage. Therefore, to prevent such disaster, Faculty of Law encourage sustainability, the future of Kalimantan, within specific curriculum as follows: Law of Coastal and Sea, Law of Forestry, Climate Change Law, Mining Law. Faculty of Law will continue preserving environmental sustainability for future generations of Indonesia.
Assalamualaikum warahmatullahi wabarakatuh. Good morning and welcome to the participants of the international seminar with the theme Maritime Security and International Shipping Current Developments. Ladies and gentlemen, distinguished guests, dear Rector of Mulawarman University or the representative, Dean of the Faculty of Law, Mulawarman University, and the staff, international seminar speakers, international seminar moderators, and the participants. This event was co-hosted by International Law Department Faculty of Law, Mulawarman University, the Indonesian Center for the Law of the Sea, Faculty of Law, Padjajaran University, and the Center for International Law, National University of Singapore. This event can also be watched through the Law Faculty Mulawarman University YouTube channel and via Zoom. Before we commence, I can kindly request everyone to please stand up for the National Anthem of Indonesia and March Mulawarman University. Thank you. Please be seated. As a welcome greeting to this international seminar, we present a contemporary Dayak dance which will be performed by Melinda Firsta Aidirose, Ananda Zakia Salsabila, Gita Elena, as a student of Faculty of Law Mulawarman University. This dance tells the story of girls dancing happily to welcome the invited guests, using the feather of hornbill as a dance property which symbolizes the grace of Dayak girls dancing. For the Dayak Kenyah tribe, hornbills play a very important role. Many people use it in traditional ceremonies and dances. Based on the beliefs of the Dayak Kenyah tribe, their ancestors came from the sky and turned to earth with a form that resembled a hornbill. Therefore, this dance is also often performed for various important events. Ladies and gentlemen, esteemed guests and dear participants, as we gather here to embark on the activities ahead, let us take a moment to center ourselves in prayer and reflection. This session will be led by Mr. Maskur SE MSI. To Mr. Maskur SE MSI, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi dan salam sejahtera bagi kita semua. Hadirin yang kami hormati, marilah sejenak kita berdoa dengan khusyuk menurut agama dan keyakinan kita masing-masing. Dan izinkan saya untuk memandunya sesuai dengan tuntunan agama Islam. Amin amin ya rabbal alamin. A'udzu billahi minasyaitonir rajim. Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin. Hamdan na'imin, hamdan syakirin, hamdan yuafi ni'amahu wa yukafi'u mazidah. Ya Rabbana lakal hamdu wa lakal syukru, kama yanbaghi li jalali wajhikal karim wa 'azimi sultanik. Allahumma salli wa sallim wa barik ala sayyidina Muhammadin wa ala alihi wa sahbihi ajma'in. Allahumma ya Allah, Tuhan yang maha pemurah, atas berkat rahmat karuniamu yang melimpah, kami dapat hadir bersama dalam acara yang penuh berkah, yaitu acara International Seminar Maritime Security and International Shipping Current Developments. Ya Allah, ya Rabb, ya Malik, hanya karena kuasa-Mu kami dapat berkumpul di sini bersama hari ini, berdiskusi untuk berbagi ilmu dan bersyukur atas nikmat-Mu yang tak ternilai. Allahumma inna nas'aluka salamatan fid din wa afiatan fil jasad wa ziyadatan fil ilmi wa barakatan fil rizki wa taubatan qoblal maut wa rahmatan indal maut wa maghfiratan ba'dal maut. Allahumma hawin alaina fi syakaratil maut wa najata minan nari wal afa indal hisab. Rabbana taqabbal minna innaka antas samiul alim wa tub alaina innaka antat tawwabur rahim. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzabannar. Subhana rabbika rabbil izzati amma yasifun wa salamun alal mursalin walhamdulillahi rabbil alamin. Assalamualaikum warahmatullahi wabarakatuh.
Ladies and gentlemen, let's welcome the opening remarks of the Rector of Mulawarman University. And this time will be represented by the Dean of Faculty of Law Mulawarman University to formally start this international seminar. Let's welcome the opening remarks by the Dean of Faculty of Law Mulawarman University. I'd like to invite Mr. Dr. Mahendra Putra Kurnia, SHMH. Please welcome.
Assalamualaikum warahmatullahi wabarakatuh. Good morning to all of participants. First of all, I would like to express our deep apology from our rector, who was supposed to be here with us, but he have another duties that could not left behind, so it delegated to me to open the seminar, and I will read our rector remarks. First, our rector welcome to all of seminar participants today, especially delegates from Indonesia Center for the Law of the Sea, Faculty of Law Padjajaran University, Mr. Gusman Siswandi and Ms. Davina Octaviana, and also from the Center for International Law, National University of Singapore, Prof. Robert Beckman, Ms. Dita Liliansa, Mr. Ong Jihao, and Mr. Taufik Nugraha. Warm welcome from our rector and to all of participants here. And thank you for collaborating with the Faculty of Law Mulawarman University in developing legal science, especially in international law. We hope that this collaboration not stop in this event, but we can make a long collaboration in the future. Mulawarman University, with the main scientific pattern of tropical studies as the basis of for the implementation for the Tridharma of higher education, always support every activity oriented to the development of science and community service. The international seminar with the theme of maritime security and international shipping current developments and continue with a tour to the Nusantara capital deserve high appreciation as an effort to contribute to the development of legal science. And through the papers presented later, it is expected to be applied in solving various legal problems, especially legal problems that arise in the development process of the capital Nusantara. In the end, thank you to all parties who have contributed to the success of this event, and hopefully this event can bring benefit to all of us. Enjoy Mulawarman University, enjoy Samarinda, enjoy East Kalimantan. Samarinda, 6 Desember 2023, Rector Profesor Dr. Insinyur Haji Abdul Nur, MSI IPU. Thank you.
Now move on to a very special moment of recognition and appreciation. It is with great honor that we present souvenirs to our esteemed partners. I'd like to invite the Rector of Mulawarman University, represented by the Dean of Faculty of Law, Mulawarman University, to kindly come forward to present the souvenirs to the Indonesian Center for the Law of the Sea, Faculty of Law, Padjajaran University, to Mr. Ahmad Gusman Siswandi, SHLLM, PhD, and the Center for International Law, National University of Singapore, Professor Robert Beckman, kindly come forward. We continue to photo session. Two speakers, moderators, lecturer, please come forward. Furthermore, together we will listen to a keynote speech that will be delivered by Ministry of Foreign Affairs of the Republic of Indonesia, Director for Legal Affairs and Political and Security Treaties. To Mr. Indra Rosandri, welcome.
Thank you very much, moderator. I hope you can hear me well. Professor Abdul Nur, Rector of the University of Mulawarman, who is represented by Dr. Mahendra Kurnia, Dean of Faculty of Law, University of Mulawarman, Professor Robert Beckman, National University of Singapore, Dr. Gusman Siswandi, Faculty of Law, University of Padjajaran, distinguished speakers and participants of the seminar, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera, namo buddhaya, santi santi salam kebajikan, and very good morning to you all. First and foremost, it is a true pleasure for me to deliver a keynote speech on behalf of Ambassador Amdi Jinapu, Director General of Legal and Treaty of the Ministry of Affairs of the Republic of Indonesia in this esteemed occasion. The theme of this seminar is pertinent and timely, as the Indonesian government is gearing up the development of Nusantara, Indonesia's new capital city. The seminar is also a testament that the interest of Nusantara, both from within and outside of Indonesia, continues to gain traction. In this regard, the Director General of Legal and Treaty of the Foreign Affairs Ministry appreciates and recognizes the importance of this seminar, as well as any other similar endeavor in the future. Ladies and gentlemen, there is not a better time than now to discuss about maritime security and international shipping. including how far it is heavily linked with the strategic location of the new capital. Existing and established international legal framework will have to consider the changing landscape of geopolitics and geoeconomics. Pandemics and all disruption to international shipping as caused by armed conflict have again inflicted huge impacts to seaborne trade. Against this backdrop, let me share the three underpinning imperatives which inform Indonesia's policies on maritime security and international shipping. First, sovereignty and sovereign rights. The sovereignty imperative dictates that it is important that Indonesia can ensure the exercise of its sovereignty and sovereign rights, especially over natural resources in its exclusive economic zone and continental shelf. Such would also mean to expediting the conclusion of boundary delimitation with Indonesia's neighbors, promoting cooperation in shipping or maritime sector, fisheries, and development of other maritime resources, as well as to combat illegal fishing in accordance with international law, particularly the 1982 Convention on the Law of the Sea. Second, security. Indonesia's security as a developing and aspiring nation is entangled with the ability to facilitate secure and safe international shipping. It is therefore natural that Indonesia must take assertive role to ensure the security of its waterfront, among others, smuggling, theft, transnational organized crime, and illegal, unreported, unregulated fishing. But I'm sure it will be part of the discussion in this seminar. Third, prosperity. This factor perceives the oceans as a sea of opportunities for growth and development. It is therefore an inherent national interest for Indonesia to engage in cooperation and or collaboration with other countries and partners to develop maritime infrastructures, shipyards, and fisheries industries. Ladies and gentlemen, on the other hand, upon observing the selection of topics for this seminar, I can only applaud the range and depth of the topics selected as well as the lineup of the speakers invited. I'm confident your discussion will be thought-provoking and generate challenging ideas and valuable contributions. Therefore, I would like to commend the University of Mulawarman, the University of Padjajaran, and the CIL of the National University of Singapore for organizing this important seminar. I wish you success and thank you.
Next is the introduction session from the international seminar organizer. First, from the Center for International Law, National University of Singapore, which will be delivered by Mr. Ong Chee Hao. Second, from Indonesian Center for the Law of the Sea, Faculty of Law Padjajaran University, which will be delivered by Mr. Ahmad Gusman, Siswandi SH LLM PhD. Third, from International Law Department, Faculty of Law Mulawarman University, which will be delivered by the Dean of Faculty of Law Mulawarman University, Mr. Dr. Mahendra Putra Kurnia SH.MH. To Mr. Ong Chee Hao, please welcome to the stage.
Test. Do you have my slides?
Slides.
Selamat pagi. Good morning, everyone. So, thank you for your patience during the delay getting up my slides. I think there's a slight issue with the internet. So, my name is Joel. I'm from the NUS Center for International Law, CIL, and I'm from the Oceans Law and Policy Program team. So, today I want to share with you very quickly about what we do in terms of ocean work. Next slide, please. So today I'll talk about CIL, and then I'll talk about our oceans team, as well as the research areas that we do. I'll also share briefly about the research program that we have with the Singapore Maritime and Port Authority of Singapore, as well as the Singapore Maritime Institute, as well as the academic and government collaborations that we have, research and publications, and also past and coming events that you should probably check out if you are interested more about what we do. Next slide, please. So about CIL, CIL was established in 2009 as a university-level research center at the National University of Singapore. Professor Robert Beckman, who is with us here today, was the founding director, and Ambassador Tommy Koh was the chair of our board of governors. Prof. Jayakumar was also the chair of the International Advisory Panel for CIL. Currently, it's headed by Dr. Nilofer Oral, who is our director, and also Lionel Yee, who is the Deputy Attorney General at the Attorney General's Chambers of Singapore, who is also the chair of the Board of Governors. Ambassador Koh is also the chair of IAP right now, the International Advisory Panel. And the core funding for CIL comes from the Ministry of Finance through the Attorney General's Chambers of Singapore. Next slide, please. So what is CIL all about? Our mission is to enable Singapore and the Asia-Pacific region to play a more significant role in the promotion and development of international law. Our vision is to become a regional intellectual hub and thought leader for research on and also the teaching of international law. Next slide, please. Next. We have 9 research areas. So Oceans Law and Policy on the top left-hand corner is where I'm from. We also have other teams at CIL, not just Oceans, including ASEAN Law and Policy, Investment Law and Policy, Nuclear Law and Policy, International Dispute Resolution, Teaching and Research in International Law, Climate Change Law, Public International Law, and Global Health Law. Next, please. So CIL actually moved to a bigger premises in 2015. We moved to a bigger office, and we currently have a staff of about 27 researchers and admin staff. Over the last 13 years, between 2009 and 2022, so I guess 14 years, CIL has added the 6 new research areas that you have seen just now, and it initially started with Oceans, ASEAN, and Investment Law and Policy. We have also hired approximately 63 researchers from 23 different countries, making CIL really truly international. So I'm very happy to be working with people from all around the world. We have also published more than 45 books and 2,000 journal articles till date. And we have organized numerous training and capacity building courses, which involves participants, including scholars, government officials from over 100 countries. Our Oceans Law team has also organized such training courses on maritime boundaries, the law of the sea, climate change and the law of the sea, as well as the limits to the continental shelf. Next slide, please. So more about our Oceans team, which is CIL's representative today. We have several research areas. The first is the regulation of shipping. We also have marine environmental governance. We have climate change and ocean governance, interdisciplinary research law and science, the interface of it. We also have maritime security, which is the core focus of our conference today. We also have regional oceans governance, submarine cables, and maritime disputes and dispute settlement. So the CIL Oceans team is actually one of CIL's core research teams. Next slide, please. So more about the Oceans Governance Program that we have with MPA. So MPA stands for the Maritime and Port Authority of Singapore. So since 2016, our Oceans team has received a grant from the Singapore Maritime Institute to establish the CIL-MPA Oceans Governance Research Program. It's a long name, so I'll just call it OGRP. And it's also partnered with MPA, which is the Port Authority of Singapore. So some of the objectives of this research program would be to identify and conduct research on trends and developments in ocean and environmental governance and international regulation of shipping that will be of relevance to the Port Authority of Singapore, as well as other government agencies in Singapore who are responsible for ocean law and policy and the maritime industry. The second goal is to strengthen the role of CIL and Singapore as a thought leader on oceans law and policy issues of local, regional, and global importance. And we aim to also develop and nurture local, regional, and international research talent and expertise in ocean governance. Next slide, please. For our new grant starting this year, for the next 3 years, these are the 4 focus areas that we will be looking at. We'll be looking specifically at marine environmental governance, international climate change governance, challenges to the safety and security of shipping, and lastly, implications of autonomous ships and related technological developments on the regulation of shipping, also known as MAS in short. Next slide, please. These are some of the other academic and government institutes which we have collaborated with. We have collaborated with Norway extensively, the Norwegian Center for the Law of the Sea, Innovation Norway as well. We've also collaborated with Nanyang Technological University of Singapore, as well as the Rajaratnam School of International Studies in Singapore as well. We also collaborated with St. John Islands and also MPA Academy and the Advisory Committee on the Protection of the Sea. Next slide, please. Some of the intergovernmental meetings that CIO attends includes the International Maritime Organization. So this is the UN specialized agency responsible for international shipping around the world. We also have government meetings with COP-C, OSPA, and the UN Environment Program. Next slide, thank you. We have also published research and publications. So notably, Prof. Beckman, as well as some of our CIL researchers have published the CIL Guide to the IMO. So this is a foundational basic resource to help students, maritime researchers, and also practitioners when they are researching on the role of the IMO in terms of regulating shipping. So please do check it out on our website if you are keen to find out more about how shipping works and how it's regulated by the UN. Next slide, please. Besides the CIL Guide to the IMO, we have other publications as well, which are all on our website. We have the ASEAN Blue Economy publication project, as well as various other projects that you can find on our website, but I won't go too much into detail on those. Next slide, please. We also have published several publications as well, including the navigational restrictions within the new law of the sea context, a guide on the Arctic Council, also Arctic shipping, high seas governance, and also climate change issues. Next slide, please. So more details on our publications will be found on our website. This is how it looks like on the website. When you click on publications, you can scroll and find out about the latest things. Also, depending on the filters, some of the past events and publications that we have done. Next slide, thank you. Some of the past events that we have done include a seminar on the secret custom at the ICJ, the International Court of Justice, on Nicaragua and Colombia. We have also had workshops with the Norwegian centers on the governance of the Arctic as well. We also have collaborated with the Ministry of Foreign Affairs of Singapore to conduct the Law of the Sea e-training course. Also have done some events on sea level rise, also the protection of critical maritime infrastructure in Southeast Asia, as well as the ASEAN Blue Economy, and also the conference on the challenges for addressing threats to commercial shipping. You can find them on the website as well. And also some maritime security events and the continental shelf events. Next slide. So these are some of the various events that we have done over the past year. I've just mentioned them as well, but also we have done things on MASS, the autonomous ships. We have done things on implementing the SDG goals through UNCLOS, seafarers' welfare, ship inspections during COVID-19, marine plastics, etc. Next slide, thank you. So this is my last slide. For our coming events, you can check out our website, but upcoming would be the Junior Scholar Workshop. This is not from the Oceans team, but it's also from CIL. We also have the CIL-NUS workshop on maritime boundary delimitation, which is now open for registration, so you can check it out on our website, as well as the CIL International Law Year in Review conference next year. An upcoming publication that is soon to be released also would be the threats to commercial shipping in Southeast Asia. I think you should really check it out. It's a special issue of the Asia Pacific Journal for Ocean Law and Policy, which will be out sometime soon. So please do check our website for more details. So this is just a brief overview of what we do at CIL. Thank you very much for your time.
Thank you, sir. Next, to Mr. Ahmad Gusman Siswandi, SH, LLM, PhD, please welcome to the stage.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Very good morning to you all. Greetings, ladies and gentlemen. First of all, I would like to greet the rector of Mulawarman University. Thank you for hosting this conference, and also to the Dean of the Faculty of Law, Universitas Mulawarman, and all the staff, students, and colleagues at the Faculty of Law of Mulawarman University. I would also like to say hi to my honorable and dear colleagues from CIL, Professor Beckman, Ms. Dita, Mr. Joy, and Mr. Taufik. Thank you very much for joining us with us today. And also my colleague from Padjajaran University, from ICLOS, Bu Davina. We are very sorry that not all of us can join here in person, but some of us, they are present online. So we have this Bu Klorin, Mr. Tobias, and also Prof. Eti Agus. I would also like to say thank you to the Director Indra Rosandri from Minister of Foreign Affairs for delivering the opening remarks, the keynote speech. So the Indonesian Center for the Law of the Sea was established back in 1984. So at that time, it was founded by Professor Eti Agus and also with Professor Mohtar Kusumaatmadja, as well as Professor Komad Kanta-Atmadja. And at that time, the center was involved in a cooperation with the Netherlands Institute for the Law of the Sea, or NILOS. I have been assisted generously by Mr. Taufik, actually, for preparing this video profile back in 2022. So it needs to be updated, but since now Taufik is at the CIL, so I could not disturb him, but perhaps I would like to share with you what is actually ICLOS and how then it has been developing so far since 1984. So the vision and mission of our center is to be a leading research center on the law of the sea in Indonesia that contributes to sustainable oceans. So we are very much keen on continuing our development with our cooperation, the development of our cooperation with Faculty of Law Universitas Mulawarman, since urgent about becoming the center for tropics research. Well, the climate change and also how the nexus between ocean and climate change is one of the perhaps possible avenues for us to cooperate. And we also aim to conduct research on law of the sea that promotes Indonesia's interests as the world's largest archipelagic state. It has been an honor for us to be also been initiated by the Professor Mokhtar Kusumatmaja through this center. And it was also a privilege for us to relate ourselves with Professor Tomiko. Professor Tomiko was Professor Mokhtar Kusumatmaja's best friend during the negotiation of the Law of the Sea Convention back in 1982. And at the Faculty of Law, we also have dedicated his name to be named after one of our auditoriums in the Faculty of Law of Universitas Padjajaran. So hopefully next time we can invite you also to Bandung and we can have also the event there. And in terms of research and education, we also support the education, especially in the field of the law of the sea, and also develop community awareness on the law of the sea vis-a-vis sustainable development. And the relationship between the center and also the Faculty of Law is very strong, and not only the Faculty of Law, but also other faculties at the Universitas Padjajaran. We also keen on promoting collaborative and multidisciplinary approaches in research on the law of the sea. So as I mentioned earlier, the center was established back in 1984, and it's an honor for us that Professor Eti Agus is also joining with us online. Welcome, Professor Eti. She was one of the founders of the Indonesian Center for the Law of the Sea, together with Professor Mokhtar Kusumatmaja and also Professor Komar Kantarmaja. And the Dean Idris cannot be with us here today. He has to attend the Lemhanas meeting in Jakarta, but he sends his warmest regards, so he's also one of our people. I'm actually acting as the director, so because currently I'm also serving as the Vice Dean for Academic Affairs, so as for the administrative reasons, I cannot be the real director, but so far I'm only the acting director. So next, Bu Davina, Ms. Davina will soon finish her PhD. So she's actually the aspiring director for ICLOS, almost FIFA this December. So these are our researchers. We have Bu Alia, Ms. Alia, and Ms. Davina, of course, Bu Klorin and Taufik before joining CIL. We were greatly assisted by him, including preparing this video. So thank you very much, Taufik, for your assistance. And we also have colleagues as researchers from Faculty of Law, and also from other faculties in Padjajaran University. So for instance, we have here Ms. Yulinda, Mr. Gary, and Mr. Tajuddin. They have been assisting us in some of our research projects. And we also have Dr. Arvin and Dr. Yusa from the International Relations Department at the Faculty of Law of Padjajaran University. And also we have Mr. Noir Purba from the Faculty of Marine Science, Fisheries and Marine Affairs faculty. So we are really grateful to have these people, and also we have fellow students researchers who have been also assisting us in conducting research projects, and these are some more people who have been involved with us. We have also published several research articles. As you can see, Taufik has been also one of our very productive researchers. We also wrote one of the articles together. And although not as extensive as the CIL, but we are keen to collaborate further, and hopefully we can have more research and publications in the future. This list needs to be updated, but so far we also have been conducting research at the university level, at the national and also international level. And this was one of the training programs that we conducted with the Indonesian Navy. We have also conducted some training programs with people from the Indonesian Maritime Security Agency. So they have been our wonderful partners so far, including also with the Ministry of Foreign Affairs. So we have been involved also in some research projects regarding the Indonesia's maritime boundary delimitation. So on this opportunity, I would like also to thank the Ministry for the support in our research center. So we are looking forward to continuing and furthering our collaboration, especially with the CIL, and hopefully this would be a first step for us to develop further our collaboration. And of course, also with our colleagues from the Faculty of Law, Universitas Mulawarman, we have just signed collaboration agreement earlier this year with the Mulawarman University Faculty of Law. So I hope that the research and also other activities in the field of the law of the sea will be furthering, helping us to further our future research. Thank you very much for your kind attention.
Thank you, sir. Next to Mr. Dr. Mahendra Putra Kurnia, SHMH, please welcome to the stage.
Okay, Assalamualaikum again, and good morning again. So, I would like to introduce our department, International Law Department. Actually, for the first time is in 2017, because due to the changes of our curricula, we have 5 department in our faculty. One of the department is International Law Department. So International Law Department actually established since 2017. So this is our 6th year for our existence in Faculty of Law. And until today, we only have 4 lectures in International Law Department. One of us, all of us is now joined with us in as a committee. So we have Miss Griselda as the one of our International Law lecturer, and Miss Rika and Mr. Sukri will be in the panel 3 moderator today. And not like the other department, like a criminal department or private department. Since 2017, not many students have interest in international law science, international law department. Each years we only have around 9 until 50 for every semester, for every year, students join the law department, international law department. But we always make a wish that in the future, the number of students that interest with international law department will be increased. But now we only have around 10 students, only 10 students that have interest with international law. You can imagine we only have 4 lectures, 10 students and 10 subjects. So it will be a small class, and we can maximize the material, and we always have a discussion. And in international law, international department, we always use a case to learn about something happen in international law, and the lack of numbers of us do not influence us to continue developing international law, and one is true like in this seminar. So we hope in the future we can cooperate more to develop international law with Padjajaran and with Center of International Law from National University of Singapore. So in this event, I would like to say thanks to our partner today, Faculty of Law, Padjajaran University, and CIL Center for International Law, National University of Singapore. We hope that our cooperation, not just in this seminar, but in the future, we can do something maybe like a joint publication or joint seminar or joint to develop our lesson in international law, especially in maritime law, because maritime law is one of our subject that we have three subject that relate with maritime subject, like we have hukum laut internasional, international law, we have hukum kewilayahan negara, state territorial law, and we also have border state subject. So through this seminar, I hope we can have new experience, new knowledge from Padjajaran University and from National University of Singapore. So thanks once again for this cooperation, and we hope we can continue our cooperation in the future. Thank you very much.
Thank you, sir. Dear audience, the next event is a coffee break. The coffee break is scheduled for 5 minutes, so we'll be back at 10 past 8 a.m. So please enjoy. You are enjoying the food. Now we move on to the discussion session. This discussion session 1, international seminar, will be guided by the lecturer of the Indonesian Center for the Law of the Sea, Faculty of Law, Padjajaran University, Mr. Ahmad Gusman Siswandi, SH LLM, PhD. Before that, let me read the moderator's profile. Mr. Ahmad Gusman Siswandi, SH LLM, PhD, completed his Bachelor of Laws at the Faculty of Law, of Padjajaran University in 1998, obtained a Master of Laws from University College London in 2005, and a Doctor of Philosophy degree from the Australian National University in 2014. And his recent publication in 2018, Marine Genetic Resources, Beyond National Jurisdiction and Sustainable Development Goals, the Perspective of Developing Countries. In the same years, Indonesia's regulation and policy in the energy sector, urgency to promote energy efficiency in urban areas, and international law, global environment, and Anthropocene. To Mr. Ahmad Gusman Siswandi, SHLLM PhD, time and place are yours.
Thank you very much for the kind introduction. Good morning once again, ladies and gentlemen. May I invite all the speakers to join me on the stage. Professor Beckman, Ms. Dita Liliansa, Ms. Yuniarti, and Ms. Davina Oktivana. Wherever. Yeah, sure. So the first, second. Okay, sure. Davina, mau di mana? Ya, oke. Ya. Bu Yuniarti. Do you want to? Okay. So just. So, in this first plenary, we'll be discussing about general instruments, international instruments, especially related to international shipping. So it's an honor for us to have Professor Beckman, Ms. Tita Liliansa, Ms. Yuniarti, and Ms. Davina Oktivana. And for the session, we'll be having first a presentation from Professor Robert Beckman. He's an emeritus professor and also co-head of Ocean Law and Policy Program at the Center of International Law, National University of Singapore. And as you can see from the presentation earlier, he was also a founding director of the Center for International Law. So it's a privilege to have you with us, Professor Beckman. So we'll give you 15 minutes for your presentation. Thank you.
Thank you very much. I must confess I have prepared more slides than I probably have time for, so I will go through them quite quickly. But those of you who are interested, we will make them available on the CIL website. I'm looking at the importance of 1982 Law of the Sea Convention to Indonesia. Is this going to work? Not working. Okay. Indonesia and rights to resources under 1982 Law of the Sea Convention. This was Indonesia before 1957, where Indonesia only had a 3 nautical mile territorial sea around each individual island, and everything beyond 3 miles was high seas. So Indonesian law didn't apply. There was high seas fisheries. Every state could exploit the fisheries or the so on and so forth. Next slide, please. Now, the first Law of the Sea Conference was 1956 to 1958. During that conference, the very famous Duanda Declaration was declared, where Indonesia declared archipelagic waters for the first time, but it was not accepted in the law of the sea. The 1958 convention does not recognize archipelagic baselines, and it did not agree on the breadth of a territorial sea. Next Now, the third conference on the law of the sea took place for a very long period, for 9 years, from 1973 to 82. Indonesia was very ably represented by Dr. Mokhtar Kusuma Maja and Hashim Jalal. I actually know Mokhtar, I knew Mokhtar, and I worked with Hashim Jalal for many years on South China Sea issues. But Indonesia was a major beneficiary, or was victorious in the Law of the Sea Convention, because a 12-mile territorial sea was recognized. Indonesia's push for archipelagic states was recognized. The compromise that Indonesia had to meet was special rules on straits use for international navigation. Those rules were drafted with the Straits of Malacca and Singapore in mind, and the rules on archipelagic states and archipelagic sea lanes passage were drafted with Indonesia in mind. So the rules at the conference focused meeting the requirements of Southeast Asia, balanced against the major powers wanting their naval ships to be able to exercise passage. Next slide. But here was victorious. It recognized the right of archipelagic states to claim sovereignty over all the waters, from baselines connecting outermost points of outermost islands and drying reefs. Sovereignty of the archipelagic waters, subject to same passage rules for ships. But territorial sea of 12 nautical miles was also recognized, and 2 new resource zones were put in, the 200-mile economic zone, and the continental shelf was extended with a new definition of continental shelf, allowing coastal states to claim beyond 200 nautical miles. Next slide. This is I'm just going to go through this very quickly. This is thanks to Andy Ansano from Gajah Mada University. But coastal state and archipelagic waters and territorial sea, the coastal state has sovereignty of the coastal state. Criminal laws, of course, apply to passage regimes. Coastal state have rights and jurisdiction to all the resources in the water and of the seabed and subsoil. Next slide. Indonesia and the economic zone. This is where Indonesia was a major victor in the Law of the Sea Conference. It's the largest archipelagic state in the world. You're more than 17,000 islands. You have a land area that's very large. But the third point on the bullet point, your maritime area is 5.8 million square kilometers. You have a large territorial sea, a very large archipelagic waters, and a very large economic zone. You are the 6th largest economic zone in the world. The only countries with larger economic zones are the major colonial powers, the US, France, UK, I think Russia is in there, and Australia. But you're number 6 of all the countries in the world. And you've also been able to claim an extended continental shelf. Now, the economic zone is the most complicated for government officials to understand, because it's a dual-use zone in which coastal states have sovereign rights to the resources, but other states retain their freedoms of navigation and overflight, including military uses. The other lawful uses of the sea language, which put in the convention, was intended to allow the navies of the world to go through archipelagic waters and through straits used for international navigation, but have complete rights in the economic zone to continue to carry out naval operations. Next slide. Coastal state has all the rights to the resources. Fisheries, hydrocarbons, minerals. Other states have freedom of navigation. So the economic zone is a resource zone for purposes of the coastal state, but it's where other freedoms apply in terms of other states. And coastal states must give due regard to the rights of others, and others must give due regard to the resource interests of the coastal state. Continental shelf if you are blessed with a extended continental shelf that goes beyond 200 miles, the coastal state can also claim that. Next slide. Here's the example. If I have basically all of your maritime zones are measured from the baseline along the coast. There's first a 12-mile territorial sea, then an economic zone where you have the right to the resources in the water and under the water. If you have a broad shelf, you can claim an extended shelf. Next slide. This is what happened with Indonesia compared to that first map. The light blue area or light greenish area in the middle is your archipelagic waters, sovereignty subject to the passage rules. The blue area is the economic zone, where you have sovereign rights to all of the resources in the water and under the water. Next slide. This is an example. I show the Europeans how much larger Indonesia is than Western Europe. If you impose a map of Indonesia, I got this from my friend, your ambassador to Germany, Arif Avazo Gaseno. But if you impose a map of Indonesia on Western Europe, it covers all of Western Europe and goes through Eastern Europe. Similarly, it's much larger than the United States. If you impose a map of Indonesia on the United States, it is far larger than the United States is. But there's a better example, again, from Andy Angsana, which shows not only your economic zone, but also your potential extended shelf claims in orange area. So Indonesia is a major, major victor in law of the sea. You're the largest and most important archipelagic state. Your claim to archipelagic waters was recognized in the new convention. You have a large EEZ at a continental shelf. The trade-off, the major powers have the right to pass through your waters and to use the economic zone of you and every other state. Right of all states to transit. And this is why Indonesia and Southeast Asia was the focus of discussion in the Law of the Sea Conference. Because to move from the Indian Ocean, from Europe or Middle East or India to East Asia, you must go through Indonesia waters. You must either go transit the Straits of Malacca and Singapore or go through Sunda or Lombok Makassar. And therefore, in order to move their navies around the world, they insisted that special transit rights be applicable to all states. Otherwise, the shipping would have to go all around Australia in order to go from Europe to Japan. 1980 UNCLOS gives you the USSR and the US. Again, at the time, it was the United States and the Union of Soviet Socialist Republics, or USSR, that insisted on the naval rights, traditional rights, in order to pass through the archipelago. And that's still the law. If you look at shipping density, you see the big red line on the left side of the screen. That's the shipping that goes through the Straits of Malacca and Singapore. Then down below Sumatra, you have the Sunda Strait. And then you have Lombok Makassar, where is this third area of the major shipping routes through Southeast Asia. Those are the major routes for navigation. Passage rights of all ships, innocent passage through territorial sea and archipelagic waters, transit passage through straits used for international navigation. This was the compromise that is still debated, I think, in Indonesia. Ships and aircraft have archipelagic sea lanes passage through the routes normally used for international navigation through Indonesia's archipelago. The entire lower half of the Malacca Strait, because of your boundary with Indonesia, with Malaysia, is transit passage through waters. I'm quickly going to go through these. Transit passage and archipelagic sea lanes passage. This is the major differences. Innocent passage is only ships. Transit passage and archipelagic sea lanes passage is also overflight for aircraft. Ships transit in their normal mode if they use transit passage. The normal mode of a submarine is underwater. If the submarine is going through innocent passage, it must surface and fly its flag. But submarines can go through the Makassar Strait submerged because it's deep enough. And this is the compromise that was reached in the Law of the Sea Conference. To regulate passage through the major sea lanes, the coastal states must propose regulations to the International Maritime Organization in London. Singapore, Malaysia, and Indonesia proposed rules regulating ships through the Straits of Malacca and Singapore. And within the last 3 years, Indonesia has proposed regulations and had them approved through Lombok and Sunda Straits. You have a partial designation of sea lanes through your archipelagic waters. This was approved by the IMO as a partial designation, which means your major powers say they can continue to exercise passage on other routes normally used for international navigation. That's what the Australians believe. So, just a quick look at a map again. We're paying attention to this as we see the new capital may change. We're looking at your area and the East Kalimantan. And it's critically important because the Makassar Strait, of course, the major shipping of the submarines, including the submarines that go submerged, would be through Makassar and Lombok. And therefore, it is likely that the Makassar Straits are going to be much more important than they were. It's likely from our point of view that Balikpapan is probably going to be a much more major port, and the whole world, I guess, in East Kalimantan is gradually going to change. What that means in terms of the Indonesian Navy, it's my understanding you now have a Western Division and an Eastern Division. I've read some speculation that they may want a Central Division because critically important to your security will be the passage through of Chinese and U.S. submarines, for example, through Makassar and Lombok. My conclusions, Makassar Strait is now used by foreign submarines and other warships to transit in their normal mode, which is submerged. It's also a major route for merchant ships, including the largest oil tankers. If the capitals move to East Kalimantan, the Makassar Strait and Balikpapan are likely to become much more important, much busier. Indonesia will therefore have to consider the economic and security implications of these developments. And therefore, I think I'll rest my case at that one. Thank you all for your attention.
Thank you very much, Prof. B. Perfect timing as well. So I think this is, has been a very important presentation to start our discussion today, how significant it is the relocation of new capital to this very province. Thank you very much once again, Professor B. Next, we have Ms. Dita Liliansa. Dita is a research fellow at the Center for International Law, National University of Singapore. She received her Bachelor of Law from Universitas Indonesia and also her Master of Laws from University of Washington. She has published extensive research in the field of law of the sea, through which she was also recognized as she won the ASEAN CIL Junior Scholar Award. Dita, the floor is yours.
Thank you, Pak Gusman. Selamat pagi, selamat siang. It's very nice to be here back in Indonesia. I think it's been a while since I'm speaking in Indonesian setting, so I'm very excited for this opportunity, especially being in the same panel with esteemed colleagues, especially my boss, Professor Beckman. I think this is the first time, Prof, we are on the same panel. So very happy. And I'm also very happy because my boss came before me because he has beautiful slides with beautiful pictures that I don't. I'm just a typical lawyer with very dry slides, with full of words. So thank you, Prof, for that. And I'm just gonna pick up some things from what Prof B has said, but then really just compliment on what he said about the transit passage, archipelagic sealant passage, basically exploring what kind of passage regimes that we have at the moment in time. Hence, I will also point out, specifically, what is the difference between passage regime under the Law of the Sea Convention and the Montreux Convention. And why is it relevant? Really, it's because the Montreux Convention has a wartime provisions that the Law of the Sea Convention doesn't have. So, because now the world is very volatile, we've seen a lot of conflicts, international armed conflicts, in many parts of the world. I'm sure Indonesia has been following, the Palestine-Israel conflict, but there's also Russia-Ukraine conflict. And there's also possibility of future conflicts as well. So I think looking into how we see this in the context of peacetime and wartime would be very much relevant. Yep. So just an overview. Oops, I think I go too far. Oh, sorry. Can I? Sorry. Can I go back few slides to overview? Yes. Overview before. Yeah. No. So way ahead. So sorry. The second slide. Before. Yeah, second. Yeah. Thank you. I thought this is working. Apparently not. So, sorry. Could you go back to the second slide, the overview? Yes, this is overview. No, stop. Can you move back? Previously, not forward, previously. I don't touch anything, so. Yeah, all right. So yeah, this is correct. Okay. Sorry for the hiccups. So yeah, and I'm glad there are so many students here. I don't know if you've taken Law of the Sea, but if you do, probably you're familiar with some of the terms I put out here. Maybe it's just a refresher for some of you or many of you, I'm not sure. But so really, I'm just gonna talk about innocent passage, transit passage, archipelagic sealant passage, freedom of navigation, and then moving on to Montreux Convention. So really the first four are the rights that ships have under the Law of the Sea Convention, and then after that, we can see how it is different with the Montreux Convention. Next slide, please. Next slide. Yes. So, up. No, previously. Yeah. No, before that. Sorry. Could you move one slide before? Yes, please. Yeah, just right there. Sorry if it's going back and forth for these technical difficulties. But basically innocent passage, maybe you can already guess from the title, it is an innocent passage, which means, it has for peaceful purposes, it cannot be prejudicial to the peace, good order, or security of the coastal states, which means all ships can enjoy this right of innocent passage through the territorial sea, which Prof. B has already explained. Coastal states have sovereignty, right? So even though you have sovereignty, it's not the same as sovereignty over your land, for instance. There are still rights of other states to enter your territory even without your permission, because they have the right of innocent passage. And as a coastal state, they may not hamper the innocent passage of foreign ships through their territorial sea. And also please note that innocent passage also apply in archipelagic waters, in areas where, beyond the archipelagic sealant passage, basically. Next slide. Yes. So these are just a list of things. Yep. So these are just a list of things that would make a passage not innocent. Hence, if it's not innocent, coastal state may take necessary measures to ensure the passage is innocent and stuff. So there are a list of things, and I provide like 3 slides. So any threat or use of force, any exercise or practice with weapons of any kind, basically anything that does not have any direct bearing to passage. So anything other than passage, that would be considered not innocent. Next slide, please. I'm gonna have to move very quickly because of this. So, yes, next. Yes, oh, no. Next. Sorry, next. Next. Yes, please stop there. Oh. Good thing I make you laugh because I'm usually not funny. So, just next slide, please. Yes, please stop there. No. Gosh, don't know. Yes, this one. Oh no. Yes, that. Stop right there. Yeah. Oh. Okay, I'll just speak, and then you see whether it comes out. Otherwise, we will run out of time. I don't want to eat into Budafina's time. So really, there are special passage rules in territorial sea. As Prof. B mentioned, submarine, basically all ships, including submarine, have the right of innocent passage. But then for submarines, because their normal mode are submerged underwater, but then in order to exercise their innocent passage, they have to navigate on the surface. So just to just to show that this is innocent. And there are also rules with regards to foreign nuclear-powered ships and ships carrying nuclear and other inherently dangerous or noxious substances. They may have to carry documents and observe special precautionary measures established by the international agreements. Next slide. Just one slide. Okay. And then, of course, coastal state have the right to prevent passage, which is not innocent. And because this is innocent passage through the territorial sea, it is also suspendable if, if there is it is essential for the protection of its security, including for weapons exercises. But they have to specify in which area of the territorial sea, without discriminating among the foreign ships. And after innocent passage, we also have transit passage through the straits used for international navigation. So a good example that Prof. Beckman has mentioned is the Straits of Malacca in Singapore. Basically, all ships enjoy the right of transit passage. Unlike innocent passage, this right cannot be suspended at all times, literally at all times. So because littoral state cannot impede transit, they may also not allowed to impose tax or toll, for instance. But then another difference with the innocent passage is that with innocent passage, submarine must be navigating on the surface, but then with transit passage, they may navigate below water because that's their normal mode. So basically, all ships may use transit passage in their normal mode, and then it has to be continuous and expeditious. Of course, they must comply to the generally accepted international standards, in which you have to go through IMO if you want to adopt special rules that you want to apply in the straits that fall within your sovereignty. For instance, the Straits of Malacca in Singapore, they want to impose traffic separation scheme. Then they go to the IMO, submit a proposal where other states can comment, and then hence the IMO would adopt the scheme. Also, the transit passage also includes the rights of overflight for aircraft, and it cannot be suspended, like I said. And the coastal states may regulate the transit passage over the straits used for international navigation to the extent that it complies with the generally accepted international rules and standards. So it's just giving effect to that rules and standards, but not imposing your own national laws, that are going against what is generally accepted by international community. And now I think the most relevant for Indonesia that I'm glad Prof. B has shown the three lanes is the archipelagic sea lanes passage. So ships and aircraft have the right of archipelagic sea lane passage through routes normally used for international navigation. So I think the term routes normally used for international navigation may be debated by some states, which is why I think it's good that, UNCLOS specifies that you have to go to IMO to designate the sea lanes. But in the event that you don't have a designated archipelagic sea lanes, then other states may still be able to exercise their rights of archipelagic sea lane passage through the routes normally used for international navigation. And outside of that, like I said, innocent passage apply. So in short, we have seen ships basically have a ton different rights to traverse through the waters of the coastal state. There is nothing that would prevent them exclusively to not use the waterways. Of course, innocent passage has some safeguards. But then that's very limited. But in overall, I think in general sense, all ships have the right to transit through other states or other states' waters. But then what about the EEZ? I think the EEZ is a unique zone and it's hybrid zone. So sometimes maybe government officials, law enforcement officers are a bit confused as to, is this our water and to what extent? So EEZ is the coastal state's water for the purpose of, the resources. Other than that, check UNCLOS again. And I'm saying this in the context of passage regimes because in the EEZ, what applies is freedom of navigation because EEZ is high seas for the purpose of navigation. I hope I'm clear on that. And because of that, in the EEZ, all states enjoy high seas freedom of navigation, which means, submarine, they may submerge, they may traverse on the surface, whatever they desire, basically. And of course, there is an exception within the Law of the Sea Convention, which is Article 35C, which we will discuss soon, which is really about the Montreux Convention. So Article 35 states that straits regulated in whole or in part by long-standing international convention in force are exempt from Part 3 and the transit passage regime under the Law of the Sea Convention, which means this provision under the Law of the Sea Convention confers a special status upon the Montreux Convention or the Turkish Straits, which we will see in a second. Which you will hear because obviously my slides are not synced to what I'm talking about. But the Montreux Convention is very special treaty because it has both peacetime and wartime application. Whereas if you read the Law of the Sea Convention, no, it does not have something like that. Because, the preamble says that it has, the oceans shall be used for peaceful purposes. Hence, I think scholars have questioned the applicability of the Law of the Sea Convention in wartime context. But then for the Montreux Convention, it's more clear-cut. But the Montreux Convention only applies to the Turkish Straits, which are the Straits of Dardanelles, Bosporus, and the Sea of Marmara. So this exception under Article 35C only applies to these straits and these straits only. That's as far as I know. So I think there may be temptation for some states to derive some of these provisions to apply to other parts of the world, but then under what grounds, right? I think it would be very hard to argue that this would apply to other parts of the world. And basically, I think the specialty about the Montreux Convention is that it allows Turkey, which is the literal state of the Turkish Straits, to govern the Turkish Straits in peacetime and in wartime. And then there are privileges as well given to certain states, which are the Black Sea powers. So like Turkey, Romania, Bulgaria, Georgia, Russia, and Ukraine. So they have more rights compared to the rest of us, including us. Like I said, it has peacetime and wartime application. So the wartime application, they're also very specific. So if it's wartime and then the next question is, what is the status of Turkey in the war? Is it a party to the war, or is it neutral, or is there something else that would, put Turkey to invoke special rules to the Strait? Like, for instance, if they think there is a threat of imminent danger of war to Turkey. So kind of like, I wouldn't say preemptive self-defense, but kind of like a preventative measures to threat of imminent danger based on Turkey's assessment, of course, as a literal state. So in peacetime, all foreign warships enjoy the right to transit the Turkish Straits, but non-Black Sea powers, which means most countries in the world, including Indonesia, for instance, are subject to certain general restrictions. For instance, restrictions on the class, on tonnage, on duration of stay. So they're very specific. And I will not go into details because really the point of this is just to show the main principles and how they differ with the Law of the Sea Convention. And then, next slide. And in peacetime, it does not allow any access for submarines or aircraft carriers of non-littoral states. Non-littoral states here means non-Black Sea powers. That means only Black Sea states, may have their submarines or aircraft carriers transiting through the straits. Other states, only warships. Warships, except submarines, because submarine is a warship. But then it does not, like I said, it does not allow the passage of aircraft carriers of the Black Sea states, but it does permit the navigation of their submarines in exceptional circumstances and on the condition that they navigate on the surface during daytime and are not escorted by another vessel. So, and now what about wartime? So in wartime, like I said, they differentiate between, between the rules depending on the status of Turkey in relation to the war. So if Turkey is neutral, warship of all countries shall have access to the straits except those belonging to the belligerent states. Okay? There's an exception. So passage of warships of belligerent states is still allowed through the straits if a belligerent state is rendering assistance to a state victim of aggression, so participating in a kind of like a collective self-defense, or warships belonging to belligerent states are returning to their bases. And then what about merchant vessels? So for merchant vessels, basically when Turkey is neutral, merchant vessels shall still enjoy the freedom of transit and navigation in the straits as they do in peacetime. So basically, the peacetime rules still apply for merchant vessels. But when Turkey is a belligerent, then Turkey has absolute discretion to regulate the passage of warships, whether belonging to belligerents or of the Black Sea powers or not. Merchant vessels not belonging to a country at war with Turkey may still enjoy the freedom of transit like they do in peacetime, on condition that they do not, assist the enemy of Turkey. So, maybe they have to enter the straits by day, or maybe they have to follow certain routes or lanes. So those kind of precautions would apply. And there's also the final situation where Turkey deems itself under a threat of imminent danger of war. So Turkey must still allow vessels separated from their bases to return by transiting the straits, unless such vessels belong to a state whose attitude led to Turkey to believe that they have a threat of imminent danger. I hope that's clear. But yeah, it must also notify the high contracting parties, which are now consisting not only Black Sea powers, but also there are a few non-Black Sea powers, also the Secretary General of the United Nations. So that's the end of my slide, but really I think the main idea or the main conclusion of my slides is that, we now see that the Law of the Sea Convention applies in peacetime, but then there may be disagreements over whether it still applies during wartime. But if I may say this, I think the Law of the Sea Convention should apply even during wartime, especially between neutral states and between neutral and belligerent states. But then if you want to dig more into the law of naval warfare, where they regulate, the passage of ships during wartime, then you can see that the law actually preserves, the right of access to the waters, subject to some conditions, but it's not like complete restriction. So that's all for me. Thank you.
Thank you very much, Dita, for sharing your insights and showing us these complex relationships between international law of the sea, passage rights, and also some aspects of international humanitarian law. And I think this can be also very interesting for us to explore further. Thank you very much once again. And next we have Ms. Yuniarti, Bu Yuniarti. She is from the Department of International Relations, Mulawarman University, Faculty of Social Sciences, Social and Political Sciences. She is specializing in the international relations theory and also regional studies, and she has also published some articles, including the on corruption and Asian values, and also tourism development through Indonesia-France cooperation. Bu Yuniarti, the floor is yours.
Okay. Good morning. Assalamualaikum warahmatullahi wabarakatuh. It's very nice to be here with all of you, and let me begin my presentation today. The topic is a bit different with the theme, but I hope that at the end of my presentation, you will see the relation between the idea of the Indonesian new capital with the maritime security. Okay, thank you very much. Next slide, please, because I'm going to start. Okay, this is the geographically location about the relocation of the Indonesian new capitals. So, Indonesian government removed it from Jakarta to Penajam Pasir Utara, one of the kabupaten or regency in the East Kalimantan. So they are going to build all new building and all facilities in the Penajam Pasir Utara. And we call the new Indonesian new capital as Nusantara, name it Nusantara. So we're going to see the relocation legal basis here. So this is some of the legal basis. First is we call in Bahasa Indonesia Undang-Undang or Law in the Republic of Indonesia, number 3, year of 2022 on the new capital, national capital. And then the Law of Republic of Indonesia, number 21st of a year of 2023 on the amendment of Law of the Republic of Indonesia, number 3 of 2022 on the national capital city, dated on 31st October 2023, and the several government regulations, a president regulation related to the IKN, we call it Indonesia, and the regulation of the head of the IKN authority. Next slide, please. Then next, okay. This is the reason or the background why we have to relocate, government of Indonesia have to relocate our national capital. This is what the Bappenas said, that or in the Indonesian law, number 3, 2022, this is the objective. That the relocation of the national capital is one of the strategies to realize Indonesia's 2045 economic target of more inclusive and equitable economic growth through accelerated development of Eastern Indonesia. So one of the objectives is to encourage regional equity on Indonesian development, of course. So because we realize there's a gap between the Western, Eastern, and the Middle Indonesian territory on the development. Next slide, please. So related to the my theme that I'm going to talk about today is understanding the development of NCC's Nusantara in the lens of international relations. So there's several issues that I'm going to discuss it today. There are three issues that related to the development of IKN. First, the economic, environmental issues, and the traditional security. Next slide, please. Okay. First, economic issues. We do know the construction of the new capital city requires a huge amount of money. We need a lot of capitals. The total estimated development fund is 466 trillion rupiah. So where do we get this fund? It is very huge amount of capital. So this is the funding source plan. This is the government plan to fund this development. So the plan is, next slide please. There are numbers of the capital that we need to build the new capitals. But we take a look at the percentage of the funding. The 19% of the fund will be taken by from the state budget or APBN, APBN, and then the 54% is from KPBU or PPP. It's cooperation between the government and the private. And the last from the BUMN and BUMD in Bahasa Indonesia. It's about 27%. So the problem is that the 19% of the state budget that we're going to allocate it to this development. So most of the arguments come from the rejection about the state burdensome, since this is a lot of money that we're going to allocate to this development. Since we Indonesia face about the pandemic, COVID-19, and then we have to build economic post the pandemic, and a lot of issues about the maybe local, national issues about the development itself, beside the development of the IKN or Nusantara or the NCCs. So this is the big challenge for the government in Indonesia. So the government hope that this challenge could be overcome by the cooperation between the government, the private, and all stakeholders in Indonesia. That's why then the government tried to find another funding sources for this development. One of the steps effort that the Indonesian government to have conducted is economic diplomacy here. Based on the ikn.go.id or based on the Otorita IKN data, in the 2023, this is several economic diplomacy that have been conducted by the Indonesian government, whether it's toward countries or international institutions such as Russia, that we already in the stage of getting the LOI, letter of intent, and then USA, and then South Korea, via the KOICA, or Korea International Cooperation Agency, and then Islamic Development Bank, and then Saudi Arabia, and Aqua Power is already signed the LOI. That's the latest news about this diplomatic, economy diplomatic. And then Greece. We also promote this cooperation and investment offer to the Greece, and then India, and their government already visit Nusantara in 20 October 2023. And the next institution, which is focus of Indonesian government to invest in this development is Tony Blair Institute, and the government of Indonesia and the Tony Blair Institute already signed the MOU on sustainable and smart city, and the last with the LUG at factory, and also MOU on smart city and smart city collaboration. Next slide, please. But the important thing is, we also hope that the investment is not only going to be invested on the IKN development itself or only for IKN, but also to develop the economic potential of the East Kalimantan. We need it, since we have a lot of economic potential that have not been yet explored well. Nowadays, economic of East Kalimantan depend on the extraction, the mining. 54% economic growth in East Kalimantan depended on the mining or extractive economic. If you take a look at the investment in the East Kalimantan, which have a very long coastline, the investment in that sector is zero. The local part, but for the local investment is 0.1% of the total economic growth or contribution to the PDRB of East Kalimantan. So it's kind of like ironic. So the investment should be allocated also to develop East Kalimantan economic potential. If we can achieve that goals, so I believe that a development gap between East Kalimantan and the other province of Kalimantan in the regional level or in the national level between Kalimantan Island in the other islands of Indonesia will be overcome. As we see the economic growth in Indonesia 2022 based on the region, Kalimantan is the second lower, in the second stage of the lowest stage in here compared to Sumatra. So this kind of gap that should be overcome. Next slide, please. I'll just skip it. Okay, thank you. And the second issues we talking about the international relation lens is about the environmental issues here. Now we take a look deep about the location of the Nusantara, that administratively the new capital city area is located in two existing regencies, namely Penajam Pasir Utara Regency and Kutai Kartanegara Regency. This area located in North Balikpapan City and south of Samarinda City, which land area is approximately 256,142 hectares and a seawater area approximately 68,189 hectares. So what is the consequences? This is the government plan. The next slide, please. This is the government plan about the Nusantara area. They have a very nice concept of development, kind of like the forest city, green city, sustainable city, green economy, green energy, and circular economy. It's really very, very nice, the best concept for Indonesia. But there's issues here that we're going to take a look deeper and deeper. Now, although the concept to be applied in the IKN is develop and green city of the future, with the 70% of it being a green area with various development concepts offered, the problem is that the status of the land area used is a forest. It's a forest. means that even if 70% the area we're going to be a green city or something else, but the 30% is being deforested, we're going to lose our forests. Can you see? So, in the side meeting of G20 presidency, June 10, 2022, Indonesia promises that they're going to reduce the greenhouse gas emission by 29% by the 2030 and achieve zero emission by 2060. Now, can you imagine, can we get it? East Kalimantan forest, whether it is in the Panjang Pasir Utara, Berau, so on, is the world long. So this is something that we have to worry about. Next slide, please. Next slide. Next. This is the picture that I got from the VOA. This is the area of the Nusantara. Tomorrow, Bapak Ibu will be seeing this kind of forest. Will it remain the same if Nusantara is built on it? So we have to aware about our forest loss because of the Nusantara development. Okay. Now we move to the third issue here, a security issue or traditional security issue, if I may say it's traditional security issues. Now, in a geographic perspective, the archipelago position on the island of the Borneo is vulnerable to the threat from the land, sea, and the air. And from a geopolitical perspective, next slide, please. There is the possibility of a hegemonic war from the major powers within the area. This is a potential threat. Transnational crimes such as trafficking in drug and person as the consequence of the innocent passage, it may be raised from the Alki too. And then Nusantara is adjacent to tourist transit triangle region from the Sulu, Sabah, and Poso. And the escalation of the dispute of South China Sea and the Ambalat. We also have to aware about this escalation dispute since Nusantara is located in Kalimantan. And then Nusantara is also within the range of ICBM and hypersonic missile of certain countries. And the last, Nusantara is surrounded by the three defense security alliances, such as FPDA, AUKUS, and Chinese OBOR and BRI. Next. This is maybe some picture that I can present to you that hopefully can make it more easier to be understood. Where is the Nusantara located? That is very close to the Alki-2. In the line in the middle that cover the Sulawesi Sea, Makassar Strait, Lombok Strait, and Lombok Sea. Trafficking, illegal fishing, it happened there. And then next slide, please. How can we see the location of the tourist triangle? It's very close to Nusantara. Hopefully our Ministry of Defense have the best strategy to tackle this kind of threat. And then next slide, please. This is the area of the South China Sea dispute. We can see where Nusantara is and where is the claims of the partisan in this dispute. And beside the figure is the Ambalat dispute. That nowadays is become a hot issue to be discussed also. Okay, next slide, please. Okay. So this is the AUKUS range or AUKUS line. We can see where Indonesia and where is the AUKUS range of operation. We can see the target of the missiles, and then the OBOR and BRI of the China, One Belt, One Road, Belt Road Initiative of China, and then FPDA. Next, this is what I talk about the missile threat in my previous slide. This is the range of China missile force, and Nusantara are in it. Okay, the last slide. Next, okay. To address this security threat in accordance with the law of the Republic of Indonesia number 3, 2022, the defense of the capital of the archipelago adopts smart defense and dual strategy. Smart defense refers to the hard defense, and soft defense is refers to the non-military, which is its local wisdom. That I'm very interested to make research on the local wisdom in non-military defense. And the last is dual strategy, refers to the total diplomacy and smart defense. And in conclusion, the real question of national capitals become interesting topic to be discussed, since there are amount of issue embedded in it from the various point of view, including international relations point of view, where we can discuss in the local, national, or global issues. That's my topic for today. Thank you very much for your attention.
Thank you very much, Bu Yuniati, for your presentation and showing us this, not only the promising relocation of our new capital, but also some threats and challenges that I think this also lay a good foundation for us for further discussions today. Last but not least, we have Ms. Davina Oktivana. Bu Davina is my fellow lecturer and research, my dear friend at the Faculty of Law Padjajaran. She graduated from the Faculty of Law Padjajaran for her LLB and also for her master's. And currently she is undertaking her PhD at the University of Aberdeen. She's having her FIFA next week, actually, so good luck to that. With that, Bu Davina, and please, the floor is yours.
First of all, I'm sorry for the choice of the background of my presentation. It's like I thought it will be a contrast, but it turns out to be very low contrast here. Good morning. Assalamualaikum warahmatullahi wabarakatuh. Bismillahirrahmanirrahim. Distinguished speakers, esteemed colleagues, ladies and gentlemen, it is an honor for me to be here. I'm grateful for the opportunity to share my presentation today. Okay, during this event, I will specifically discuss about the legal consequences of Indonesian Marine Protected Areas, or MPAs, to shipping and navigation. Next, please. Okay, so this is the definition of MPA. Formulated by IUCN. IUCN stands for International Union for Conservation of Nature. The exact words of IUCN in formulating MPA is a clearly defined geographical area or space, recognized, dedicated, and managed through legal or other effective means. To achieve the long-term conservation, of nature with associated ecosystem services and cultural values. So from this definition, we can see that a clearly defined means the area must have a clear borders, and usually the proposed area marked by coordinates or maps. And geographical space refers to the three dimensions of MPA, which address the airspace above, the water column, and the seabed. An MPA can be established to manage one or more of these features on the condition that the ecological interdependence in this area is accommodated. Recognized indicates the management of MPA can be conducted by several interested parties as long as it is accepted and acknowledged by states, whereas dedicated implies that the MPA established under a specific regulation and managed means the denotative measures in conserving biodiversity. For example, the no-take zone within the MPA implies the area is sterile from any human activities as part of the conservation approach. So this is the important part. The legal phrase can be described as MPA requires to be recognized under the law, and they could be national law or under the international agreement. On the other hand, managed through other effective means construes as the MPA is not regulated by law but recognized under traditional rules and managed by a traditional community as well. The term to achieve suggests that the level of efficacy determined by the MPA is objective and continually monitored, evaluated, and reported to ensure their effectiveness. And the phrase long-term can be ascribed as the definitive characteristic of MPA. So any protection measures that do not include the long-term conservation cannot qualify as MPA. However, the short-term seasonal protection is still valuable for managing MPA as the complementary element. And the term conservation implies the in situ conservation of ecosystem and habitats, including the viable species populations, which refers to the definition provided under the Article 2 of UNCBD. And the phrase nature refers to biodiversity, genetic species, and the ecosystem. And the phrase associated system service suggests that their essential contribution to the pursuit of nature conservation and can be divided into 4 services, which are providing food, water, regulating surface, for example, overflows regulation, depletion, land degradation, supporting services, for example, soil formation and nutrient cycling, and cultural services, spiritual and religious and other benefits. And finally, the words cultural values. It means that regardless of the primary of MPA is to conserve nature, the protection of sacred sites or significant cultural and heritage value is also comprehended to ensure the local community, the local community's right to practice their belief is accommodated. Okay, next. Okay, so this is the category of MPA. First category is strict nature reserve, and then the second category still in category 1B, wilderness areas, category 2, national parks, category 3, national monuments or features, category 4, habitat or species management areas, category 5, protected landscapes or seascapes, and last, category 6, protected areas with sustainable use of natural resources. So in Indonesia or Indonesian MPAs usually in category 2, category 4, and category 6. And there's 2 categories that are limited the human activities. It's in category 1 and category 2. For the other category, The human activities still be allowed, but it's limited and it needs permission. Okay, next. To answer whether Indonesia needs to establish MPAs, we must first consider the international instruments that Indonesia has ratified, and this is displayed on the screen. Well, although UNCLOS does not explicitly acknowledge MPAs as a conservation mechanism or conservation tools, nor emphasizes the significance of marine biodiversity, it does establish a legal structure for protecting marine resources and preventing pollution for damaging the ecosystem. There's actually two articles, Article 192 and 194, paragraph 5, that can be contextually interpreted as the obligation for contracting states to protect and preserve rare or fragile ecosystems, as well as habitat depleted, threatened, or endangered species. And the second instrument, UNCBD, set the obligation for the contracting parties to establish a system of protected area to achieve the convention's goals. Although UNCBD applies not only to a marine area, it contributes to developing principles and approaches to establishing MPAs, and the obligation of the contracting states to establish a protected area is provided under Article 8. Ramsar Conventions, the 1971 Ramsar Convention raises awareness of the importance of wetlands, which play a very essential role in flood control by absorbing surplus water, and it can be also a source of water supply for human consumption and other purposes, of course. And the Ramsar Convention is an example that is well integrated with a system of protected areas to protect coastal areas and marine biodiversity as well. The last Ramsar COP actually has successfully established a partnership with UNCBD and includes the IUCN's categories to the wetlands of international importance. So we can say that wetlands conservation has significant influence on the effectiveness of MPA in a holistic manner. And next instrument is IC target. It's set out the 10% of coastal and marine areas to be protected in 2020. And it was restated in Sustainable Development Goals, specifically in Goals 14.5. And also I included the IMO instruments that develop available tools to promote secure navigation. I think I'm not finished with the last slide, sorry. Yes, so this is, we still discuss about the IMO instruments, and because it is one of the objective of IMO is to establish and to promote secure navigation and regulate the shipping procedures. So we have MARPOL, London Protocol, Ballast Water Conventions, the PSSA, Particular Sensitive Area, or MARPOL Special Area, are the examples of measures that benefit from marine biodiversity, benefited for marine biodiversity conservation, either directly or indirectly. Okay, next. So, establishing MPAs is widely regarded as an international obligations. under various conventions and instruments, whether it's a hard law or soft law. So the primary aim to create MPAs is to protect marine resources and preserve the marine environment. Nevertheless, the establishment of MPAs carries legal ramifications for both Indonesians and foreign vessels with regard to shipping and navigation. So this is the legal consequences derived from the establishment of MPA in Indonesian waters. Okay, next. So, next slides. Okay, so this is how Indonesia define the legal terminology of MPA. It's divided into two categories. The protected area managed by a zonation systems to achieve sustainable management of its resources and the environment, and the second is a protected area of coastal areas and small islands with certain characteristics to accomplish sustainable management of the coastal area and small islands. So, based on the definition provided, Indonesian MPA places emphasis on conserving fish resources, and it's also emphasized in addressing the preservation and protection of coastal area and small islands. So it's regulated under two different instruments in Indonesia. Okay, next. But for this theme, since it's I connected the MPA with the shipping and navigation, so this is only half of Indonesian instruments that regulates MPA. First, the law number 27, Jungto law number 1, law number 27, 2007, Jungto law number 1, 2014, regarding the management of coastal areas and small islands. Law number 17, 2008, shipping law. Law number 32, 2014 on marine law, and marine MMF stands for Ministry of Marine Affairs and Fisheries Regulation number 31 to 2020 regarding the management of conservation area. So, law number 1, 2014 actually introduced the new term of conservation area, and it applies only for coastal areas and small islands. And law number 17, 2008 concerning shipping is enacted to fulfill the need of integrated transportation system in Indonesia. Because as an archipelagic state, as an largest archipelagic state, shipping has been considered as the vital transportation mode in Indonesia. And it also has a major role in the development of the economy in Indonesia. So, law number 17, 2008 actually is conformity with international laws, specifically with IMO conventions, guidelines, and instruments. Okay, so let's skip the marine law and straight to the MMF regulation number 31 and 2020. This is the most recent ministerial regulation concerning the MPA, adopted to implement the article. I forget the article, but it's some article in management of coastal areas and small islands law. It comprises maybe more than 50 articles with the scope of conservation area plan, establishment of the conservation area, utilization of the conservation area, and supervision of the conservation area, as well as the evaluation and financial aspect. Okay, next. Okay, so this is the next slide is the different type of Indonesian algae. We have Professor B pictures and also Ms. Uni slides explain about the Indonesian algae. So this is actually the Indonesian submission to MSG IMO. The three algae, algae 1, algae 2, and algae 3. And I think we can skip this part and straight to the next slide, please. So under the MMIF 31/2020, the Indonesian AMPA can be classified into 3 categories. So this is the last version of Indonesian AMPAs. First category is park, sanctuary, and maritime conservation area. And park and sanctuary categories actually adopted from the IUCN category 5 and 6. And maritime conservation area is designated to protect and preserve the traditional cultural sites. So we have basically two level of protection: park and sanctuary for the preservation and utilization of marine biodiversity, and maritime conservation area is for the protection and preservation of traditional and cultural area. Okay, next. So every MPA in Indonesia has to include this at least 3 zones, core zones, the utilization zones, traditional zones, it's optional, and other zones. So any conservation area is required to retain a zonation conservation area, includes the core zone for the fully and highly protective conservation target, and the restricted utilization zone. It could be the sustainable fisheries and tourism activities, and other designated zones. And most of Indonesian MPA is actually not complied with MMIF Regulation 31/2020, specifically for the navigation in their surrounding areas, because most of Indonesian MPA were established before 2020, and it has like a 20-year of period, and so I don't think that Indonesian MPA has the integration between shipping and navigation into the law. So 3 more minutes. Okay, so perhaps we can skip to the next. Okay, so this is the category of activities that also must be included into the regulation of MPAs in Indonesia according to MMIF Regulation 31/2020. There's permitted activities with conditions, with certain conditions, and prohibited activities. So all the established MPA or the current MPAs that established before 2020 needs to be adjusted to this regulation. Okay, next slides. So this is actually my last slides. This is the map from the MMIF decision number 87, 2016. It's marine protected areas in East Kalimantan. and classified as a conservation area for coastal area and small islands. And unfortunately, these decisions only includes coordinates and maps, and does not specify the activities that are allowed and prohibited within the area. So MPA is established to maintain marine biodiversity conservation measures, and by regulating and limiting or prohibiting fishing and also shipping activities in these certain zones. But unfortunately, they often neglect other issues like pollution and vessel passage, which can also have a negative impact to the MPA. So it is important to note that ALKI is not subject to MMIF Regulation 2020, which is can be a significant consideration for Indonesia in recognizing its archipelagic state regime and granting navigational rights to third parties. So, and this is also a closing statement for me. It is worth mentioning that MMIF Regulation 31/2020 has less comprehensive provision for shipping and navigation than regulation governing fishing activities. Okay. Next slide. Oh, okay. So I think that will be the end of my presentation, and thank you all for your attention. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Bu Davina, for highlighting this environmental aspect. This was also one of the issues that was highlighted by Bu Yuniarti earlier. So, ladies and gentlemen, those are the presentations from the four panelists for this morning. Now, I would like to invite all of you here, the participants, if you have any questions or comments to our speakers, please. Any questions? Yes, over here. Can we have a microphone delivered to the participant? Yes, can you introduce yourself, please, before asking a question? Thank you.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everyone. Thank you for the opportunity. My name is Arif Wicaksa, and I am from the study program of International Relation. Before I ask my question, am I allowed to have more than one question or only one question, Pak? Okay, thank you for the opportunity. My first question is for Professor Beckman. My question is, based on what I know, China is increasing its activities on South China Sea, and based on their claim of 9-dash line. And then they are basically building so-called artificial island on the area of South China Sea. My question is China's activities will give impact to the UNCLOS in the future? And then is UNCLOS has some kind of enforcement mechanism to respond such aggressive activities, or is it really heavily on national power of involved countries? That is the first question for Professor Beckman. And then the second question is for Mbak Dita about AUKUS especially. I believe about several months ago, there was a joint statement of AUKUS states that they are agreed to equip Australia particularly with nuclear-powered submarines. And then I believe somehow the submarines will be passing Indonesia seas. My question is, on what basis Indonesia can deny submarines from traveling across its archipelago, its area, its territorial sea? And then the third question to Bu Yuniarti. One critical issue regarding Indonesia's new capital is the investment issues. And unfortunately, Indonesian government is struggling to find investor to its new capital. This phenomenon, however, raises my concern on to what extent Indonesian government willing to change their original standing point regarding to the new capital into something more, let's say, investor friendly. So main question is, to what extent investor demand would affect the dynamics of IKN building? And then the last question is for Mbak Davina. One interesting thing about marine protection area for me is oil spill on Indonesia Sea. How this case, especially oil spill on Indonesia Sea, can be solved? Because I believe that oil spill is one case that oftenly occurred in Indonesia. How can we, in the perspective of law, can we give solution to the problems? Probably that's all. Thank you for the opportunity.
Thank you very much, Mas Arif. So I will give the opportunity to all the speakers. Prof. B first.
Okay, first question was to me on South China Sea and China. The disputed islands in the South China Sea are claimed by China, Taiwan, Philippines, Vietnam, Malaysia to varying degrees. The law of the sea does not cover sovereignty disputes. The law of the sea assumes we know who owns the land, and it dictates what the rules are on the ocean space. China occupies about 7 of the features. Vietnam occupies many more. Philippines occupies more. But China is building up the islands through reclamation, and it's militarizing them with airstrips and missile sites, etc. The law of the sea doesn't govern that issue. The Philippines brought a case that was decided in 2016, which in effect was against China in terms of this, in terms of what they have been doing. It said that the reclamation was not in principle illegal, but it was illegal because they were violating their obligations to protect the marine environment. So in terms of militarizing the islands, Vietnam has also militarized them, and they're also engaged in island building, but not to the same level. The tribunal ruled that much of what China is doing is not consistent with the law of the sea convention, but China refused to participate in the case, and it has simply said the case is a piece of scrap paper that has no meaning. Therefore, we are dealt with the issue of China claiming sovereign rights and jurisdiction over all the area within the 9-dash line. And the Southeast Asian countries that border the South China Sea, including Indonesia, challenged that position. But at this point, there's no way to resolve it except by negotiation. So it's not a happy situation.
Thank you for the question. I think in peacetime situation, there's nothing that would allow Indonesia to restrict passage of AUKUS submarine. All submarines, regardless of the flag, whether it's Australian, American, Chinese, or whatever, they have the right, to traverse through Indonesian waters. There are 2 rights. It's either innocent passage or archipelagic sea-land passage. And as I said earlier in my presentation, innocent passage may be suspended, but that suspension is temporary and only in selected locations and for selected period, and there must be due notice. So it's not like absolute discretion on on that. But then archipelagic sea-land passage is non-suspendable. So that means there is nothing that would justify any suspension of transit rights of submarines. Because then the question is, why is it that AUKUS submarine being suspended but not other nuclear power submarine? Because AUKUS submarines, as of today, is not operational yet. That's a fact, right? But I think people keep forgetting that there are already other nuclear power submarines owned by Americans, Chinese, Russians. So what I'm trying to say is that why is it that when it's AUKUS, then Indonesia feels the need to restrict it? And then the question is, would Indonesia also do the same thing to the existing or already operational nuclear power submarines? Because then there will be like inconsistency on like why are you restricting certain nuclear power submarines and not the others. So I mean, also because nuclear power submarines have stealth capabilities, which mean they're very hard to detect. I mean, I'm not saying that there are nuclear power submarines in Indonesian waters traversing without detection, but probably there are. But at least from my quick reading, I think there was once a U.S. nuclear power submarine in the Straits of Malacca, in which the Indonesian Navy was notified. So they kind of like have a close eye on them. But then that's it. Just monitoring, just making sure nothing fishy. But you cannot like restrict or even like block the passage. I hope that answers your question.
Can I quickly make a comment on that? Yes, I think it's naive to think there are no submarines going through Indonesia's waters now. Of course they are. And the submarines go through La Sunda Lombok because the Straits of Malacca and the other route, Sunda, is probably too shallow. So it's not a question of after AUKUS submarines will go through. Submarines are going through now. The question is, can you put listening devices where you can track so you know who's in your waters?
Thank you very much. So we do believe that our government today is struggling for funding. So that's why they're going to find a lot of investment on the IKN development. But like Pak Jokowi said, that in every sector, if we try to find investment, the Indonesian share in the specific sector or certain sector must be the majority share. That's the common rule that we can understand. So that's it is should be conducted when we have to build our sovereignty over our resources, whether it's human or the natural resources. But in the other hand, our government also very open to not only kind of like the smart city investment, but recently I read the newspaper that said they also going to attract more investment on the maritime sector in the East Kalimantan. Since, as I explained before, East Kalimantan got 0.1 investment on the sectors. So I hope it's answered your question. Thank you very much.
Okay, thank you for the question. Actually, this is a very good question since oil spill is inevitable, but it's the source of, I would say, the worst marine pollution, and it could damage the MPA's objective in long term. So I would strongly suggest the government to include the prohibited activities, specifically the oil discharge that can be avoided actually. Perhaps make a border or some kind of a barricade for perhaps in a certain length to protect the marine protected area, because it's long-term conservation, so it needs to be protected systematically and comprehensively. Okay, perhaps that's my answer.
Thank you. We also have participants online via Zoom. Maybe I will check first if we have questions online. Yes, there is one. If you can display the video so we can all see. Yes. Yes, please, sir. Can you introduce yourself and then deliver your questions? Can you hear us?
Yes, I heard you.
Yeah. So
Also,
please
my
introduce
son.
yourself and you can ask a question and to whom you address your question to.
Okay, thank you very much for the time. So, my name is Harry Stan. I'm from the Batam Island. I have a two questions. One of the raises the issue on the reclamation carried out by Singapore to the impact of the Indonesian territorial sea. To the counter of the issue, Indonesian consider using the National Convention of the Law is UNCLOS 1982. But in fact, UNCLOS is 1982 does not provide to reclamation provision. This is the question to Professor Baker. So the question remains, will UNCLOS 1982 be able to fully protect the sovereignty of the Indonesian territorial sea from the Singapore reclamation treaty? This is one question. The second question is I going this question to Dr. Dita and Dr. Devina is have to spread for my question. The question is a concern of the shipping regulation. Is that particularly the transportation of the carry of a container is between a Batam Island to the Singapore. Is that using by roll and roll of facial. This my curiosity as to why is a Batam company's chassis trailer cannot operate on the Singapore road, but while the Singaporean chassis trailer can operate in the Batam, they go on our road in the Batam Island. So if we refer to the Article 21, what the mention of the Dr. Dita is Article 21, number 17/2008 of the Indonesian shipping law state that the transportation activities across to the border with the neighboring countries shall be conducted in accordance with the agreement between Indonesia government and government of the respective country. So my question is, we don't have the agreement between Indonesian and government of Singapore. This is I need what resolution of this seaman from Batam to Singapore, Singapore to the Batam. Thank you very much for my time. Thank you.
While UNCLOS doesn't really provide explicit provisions on the impact on land reclamation, for instance, vis-a-vis sovereignty. And in this case, the Singapore that has also reclaiming its island. So.
Okay, I'm sorry I didn't quite catch your question. I'm an old man and my ears aren't so good. But in terms of reclamation of Singapore, there has been a boundary since 1973 establishing the territorial sea limit between the Riau Islands and Singapore. And therefore, what is happening is Singapore is filling in the area on its side of the boundary and giving itself much less sea but more land. It doesn't in any way affect the boundary with Indonesia. The sea boundary agreed to between Suharto and Lee Kuan Yew in 1973 and then extended twice, covers the Singapore Strait. Okay, and in terms of my understanding of the traffic separation scheme, all of the ships that are going eastbound to the South China Sea are going through the Strait of Malacca from Port Klang down and through the Strait of Singapore. They are always in Indonesian waters. Okay, the entire eastbound strait is in Indonesian waters. Westbound, it's not so clear because the boundaries are not delimited in the eastern approach to the Singapore Strait. So sometimes the eastbound traffic going toward Europe will be in Indonesia waters and sometimes Malaysia and sometimes Singapore. But in westbound, but in eastbound, they're always in Indonesia waters. I'm not sure I caught the other question.
Yeah, I think the second question in regard to this shipping regulation, is it according to our law, which is the law number 17 of 2008, and it, if I get it correctly, the Indonesian government can have further agreement with Singapore regarding the shipping and freight traffic. If I get it correctly, was that the question, sir? Whether we need further agreement to implement this traffic.
Between Batam and Singapore is not too unfair to our country. Our trailer or chassis for the container cannot go to the Singapore road, but the company from the Singapore can go to our road in the Batam Island. If we call it is a sailing using the vessel Roro vessel. Is that meaning that you want the container with the chassis going to the Batam Island? But in Singapore, our container cannot go inside. But this is unfair for the law. Thank you.
Again, I'm not sure I caught the question, but traffic transiting the Singapore Strait in either direction toward the Indian Ocean or toward the South China Sea cannot really be regulated by either Indonesia or Singapore. Under the Law of the Sea Convention, the three littoral states, Singapore, Malaysia, and Indonesia, have proposed a traffic separation scheme and mandatory ship reporting, etc., to the IMO. The IMO adopts the regulations, and then every ship must comply with them. In terms of the cross-traffic between Singapore and Batam or the Rio Islands, this would be governed by bilateral agreements between Singapore and Indonesia. To come into Singapore waters, you're going to have to comply with Singapore's regulations. To go to Batam or Bintang or other islands, you have to comply with Indonesia.
I think just adding, because yeah, on that point, I'm not sure which article on my slide that you were referring to, but really the Law of the Sea Convention, yes, it regulates, the use of the sea, at the international level. But then I think at the bilateral level, like what Prof. B mentioned, I think the issue that you were asking about is something beyond the law of the sea. The use of the road, like whether the container of, the other state may use the road. That's what I understand. So I think that would be, beyond the Law of the Sea Convention itself.
The one difficult area is there is an area at the eastern approach where there's a boundary required between the three states of Indonesia, Malaysia, and Singapore, and there's yet no boundary. So sometimes what I call the bad guys will go out doing ship-to-ship transfer of drugs or other illegal activities, knowing that neither of the three states is comfortable arresting them because the waters are not defined, the boundaries aren't defined. That, to me, should be a high priority. The other issue that's going on is ship-to-ship transfers. Sometimes in Malaysian waters, if there's oil spilled from a ship-to-ship transfer of oil, the currents take it into Bintan rather than into Malaysia, and therefore the Indonesian coastline gets polluted. It's another area that should be examined.
Right. Thank you very much, Prof. D and Badita. I saw a hand, but I must confirm with the organizer first. Do we still have time for Q&A, or should we close the session? One more question? One more question. Yeah, I saw a hand. You raised your hand. Yeah, please. Can we have a microphone? Yeah. Please. This gentleman over here. Please introduce yourself, and then you can ask a question.
Okay, thank you. My name is Muhammad Faizi Oktav Herliandi. I'm a student of International Relation. Oh, okay. So I would like to inquire with Miss Yuni and maybe others too regarding the traditional issue related to trade in Zona Alki-2 or Zone Alki-2, which is near the new capital city of Indonesia. Are there concrete solution from the government regarding transnational crime issue? And then what action have been taken maybe increase the military maybe or whatever. So thank you.
Okay, thank you for the question. Well, actually, the issue on transnational crime will be discussed in the next session, but if anyone has any, would like to respond, please.
Okay. Actually, our government prepare a strategy to overcome this maritime security issues. Yeah, that as Pak Gusman said that this issue going to be discussed in the next session, but maybe I'm going to give you a split of the answer. Our government is building a new strategy, what we call maritime. What I forgot the name. It's on the. No, it's. Oh yeah, virtual maritime. Yeah, virtual maritime gate. This new strategy to tackle to handle this kind of the problems in the Alki-2. Okay, you must stay until the end of the seminar, since the issue we're going to be discussed in the next session. Okay, thank you.
Right. Okay. So I think we still have one more question. Yeah. Time for one more question. This is the last one, please. Can we have the microphone?
Okay. Thank you for your opportunity. My name is Ikhwan. I'm come from Universitas Muhammadiyah Kalimantan Timur. I have one question for Ms. Davina, maybe, relating to the marine protection area. Actually, my question, there is some connection with the previous question related to the reclamation of Singapore, but that's not my point. My point is relating to the Indonesian policy, which is reopen the legal permit to export the sea sand based on the regulation, government regulation number 26 of 2023. So, what do you think about this regulation? Do you think this regulation will threaten the marine protection area around Indonesia? Yeah, around Indonesia, because we know back to 2002, the permit already suspended in 2002. So after 20 years, it's reopened again by the Indonesian government. So do you think this regulation will threaten the area, especially the small islands around in Indonesia? Because there are some small islands are sinking because of this activity. So that's my question. Thank you.
Thank you for the question. My answer would be very naive because it's there's a new implementation regulation in 2019. It's regarding the marine spatial planning. Then there's provision that regulates for the certain strategic project, a national strategic project. It allows the central government or the government to move or to relocate the MPAs. As we know that MPAs in coastal area and small islands is the majority MPAs in Indonesia, and season exploitation could be, and I'm sure that it will be affected for the conservation in long term. But the government has some new regulation, as I've said before, in 2019 government regulation that allows the government to relocate the MPAs. So if the sea-sand exploitation is part of the national strategic plan, the government or the central government must relocate the MPA, must designate the new MPA to the other places. So, yeah, it's always the economy versus the environment protection. Okay, that's my answer. Thank you very much.
Okay, thank you. So that would conclude the panel session for this morning through this afternoon. So please give a big round of applause for our presenters. Thank you, Professor B, Mbak Dita, Mbak Yuniati, and Mbak Devina. And the next sessions will be conducted in the afternoon, and we will explore further about the relationship between the international regime related to international shipping and law of the sea to the context of East Kalimantan, and also the relocation of the new capital. Thank you very much for your kind attention once again and for your active participation. And I'm handing back to the organizer. Thank you very much.
Thank you very much to the moderator and the speaker. The discussion has given us a new perspective related to the theme. For that, let's give applause to those very insightful speakers and moderators. Dear audience, the next event is a lunch break. The lunch break is scheduled for 45 minutes and we'll be back at 1:15 p.m. For lunch, to invited guests, there will be students directing. For participants can stay in their seats. The committee will prepare the lunch, and the audience who will do Zuhur prayer is welcome to our musola, which will be directed by the committee. Thank you.